Welcome to Employment Law This Week. I'm George Whipple. On April 23rd, the Federal Trade Commission announced its final rule banning virtually all non-compete agreements effective 120 days after it is published in the Federal Register. Employers across the nation are looking for answers, and the team from Spilling Secrets was ready to jump in. Spilling Secrets is Epstein Becker Green's podcast series about trade secrets and non-compete law. Panelist and member of the firm Erik Weibust lays out the details of the ban.
Essentially, the final rule would ban all future post-employment non-competes, and it would invalidate all existing post-employment non-competes as of the effective date, other than those with senior executives. Senior executive is somebody who's in, quote, a policy-making position and earns at least $151,164 in annual compensation.
Challenges to the rule soon followed, including one our panel is watching closely from the U.S. Chamber of Commerce. The Chamber is basically pursuing four theories. First, that the FTC lacks legal authority to issue regulations governing competition of this scope. Second, that the FTC lacks the authority to ban all non-competes.
Third, the FTC can't void existing contracts, which it is purporting to do. And finally, that the justification for the rule is inadequate under the Administrative Procedures Act because it ignores the benefits of non-competes and it ignores potential alternatives that would have been more targeted than a complete nationwide ban. It's probably 8 to 12 weeks at the earliest before we get a ruling there. But again, I think most commentators would agree that it's unlikely that the rule will ever go into effect.
While this may seem like promising news for employers, Epstein Becker Green's Pete Steinmeyer says that non-compete restriction is a trend we haven't seen the end of, as shown by current pending legislation.
There are 3 bills that were introduced in the Illinois state legislature, even though Illinois just enacted comprehensive non-compete reform on January 1, 2022. And there have been scores of bills in other states across the country. And that's just not a trend that's going to stop regardless of what happens to the FTC rule. And if anything, the rule may encourage further non-compete reform efforts.
Given all this, what should employers be doing now and in the future?
Our recommended approach has been and will continue to be that employers take a holistic approach, that they use a combination of devices and tools such as confidentiality agreements, customer non-solicits, an incredibly important tool that is widely accepted, trade secret audits. What do you have as an employer? Who has access to it? What are you doing to protect it? Are you doing all of the things that you should be doing? Usage of garden leave clauses. Garden leave clauses, to me, really are the future.
Erik and Pete dive further into details about the ban on the latest episode of the Spilling Secrets podcast. Subscribe to the Employment Law This Week feed wherever you get your podcasts to hear the full audio episode and to catch all future editions of the Spilling Secrets series. Thank you very much for watching, and we'll see you next time.